Good evening. We are so pleased to have you all join us tonight. As is the tradition with the Fordham debate, we have selected a topic that is of great public interest, with passionate defenders on all sides. In keeping with the academic nature of the event, however, we ask that the audience remain quiet and respectful during the debate so that everyone may be heard. That does not mean that you cannot participate. In fact, we invite the audience to write questions on cards in your programs, and we will collect them at various points throughout the night. My colleague, Professor 3D and Professor Roski will walk up and down the aisles and collect cards when you pass them to the sides. Let me outline how we will proceed. Professor Marcy Hamilton will speak first in favor of the resolution, giving a 5 to 10 minute opening statement. Then, Chief Deputy Attorney General Kirk Torgeson will respond with his opening, arguing that polygamy itself is irrelevant and only crimes such as child abuse deserve our attention and intervention. Then, I will pose questions for the participants, one at a time, giving each about 3 minutes to address the question and allowing a minute for rebuttal. We will turn to your questions toward the end of the hour and before the participants' closing statements. Professor Hamilton.
Linda and the law school, thanks very much for including me in this very interesting and important debate tonight. As many of you know, this is an issue that's very, very important to me and that I've spent quite a great deal of time thinking about. When I first started writing about religion, my first article was an article in which I argued that there should be virtually no restraint on religious practices, that the Free Exercise Clause should in fact be interpreted as almost a given right to do whatever it was the religious entity wanted to do. As I document in God versus the Gavel, I was fundamentally wrong. And the reason I was wrong is because I was uneducated. And in the years since, I have become educated about what can happen, especially to children, in circumstances that are motivated by religion. And that is why I take the position I do tonight, which is that the polygamy laws should be enforced, as well as the child abuse laws. First, this is a fundamental question about the rule of law, the enforcement of the law, of the criminal law. The Utah Supreme Court in 1955 issued the Black opinion. It is worth rereading. In that opinion, the court created a comprehensive explanation for why the anti-polygamy laws should be enforced in the interest of children and why they should be enforced to stop the vicious cycle. Because if the cycle is not broken, the children born into it have extraordinary difficulties escaping from it. Religion is no excuse for illegal behavior. It's true for polygamists. It's true for priests who abuse children. It's true for churches that cover up child abuse. It's true for churches that permit children to die from medically treatable ailments. Second, the question in our society is increasingly becoming, what is in the best interests of the child? Now, that standard has been used in family law, but I mean something different. We are in the midst of a coming civil rights movement for children, which is to say children are becoming persons. Not very long ago, they were property. And as property, they could be forced to work on the farm or in the factory. They could be forced to take whatever treatment it was that the parents decided to dole out. That's changing. Children are becoming persons who have rights against bad treatment and against harm. Now, while it's undeniably true that not every case of polygamy includes sexual or physical abuse of children. The tendency is enough to make the assumption that a polygamous home is not a fit home for the child, which is precisely what your Supreme Court in Utah said in 1955. There are too many abuses. Now, most of the United States was utterly ignorant about what happens in many of these communities until Texas, until the Texas authorities took the children from the Yearning for Zion Ranch, and some of the truth, not all of it, but some of the truth was revealed. And what was the truth? There's no question there was sexual abuse. There's no question there was statutory rape. There is no question at all that there were boys trained to become part of a system that abused girls at an underage. Those are just facts. Those aren't made up by anybody. 10 men are now under indictment. You can't be under indictment just for having a religious belief. You have to take action. And the actions that were taken in Texas in a very small community were enough to get 10 men indicted. No other community, if it were divorced from religion, would be permitted to argue that it has some kind of constitutional right to create an environment for such abuse of children. But there are other issues that come up with polygamy. And the other issues include abandonment, neglect, fewer resources per child from the breadwinner who now piles on child after child and then expects the state to take the burden if it gets to be too much. These are just facts. These aren't theories. We know these are facts. And so either we can debate the facts or we can ignore the facts. And it's my view, and the reason I came to this debate is so that we would talk about the facts and not about the public relations or the whitewashing that has happened too often and has hurt children because polygamy was not paid attention to. There are reasons that polygamy is illegal, but whatever the reasons are in every state that it's illegal, it is the law of the state created by the state. It is permissible for a state to create religious exemptions for laws that apply to everybody else. But those who engage in polygamy in the state of Utah or the state of Arizona or elsewhere, the state of Pennsylvania, there was a bigamist prosecuted in the town next to mine several years ago. They have not succeeded in using the democratic process to get an exemption. And until they can persuade their elected representatives that their way is an appropriate way, what they are doing is criminal. Not just illegal, but it's criminal. It's a felony in this state. And child bigamy is a second-degree felony. Just as in Texas, it's the marrying of the children that is most troubling and should be most troubling to all civilized and fair-minded adults. The real problem, I think, that we face is that in the vast majority of states, polygamy is irrelevant. There just isn't that much of it. But in a few states, it's rampant. And in those states, the prosecutors have been inadequate to stop it. They have backed off from stopping it, so that the state of Utah creates what they call a safety net for criminal behavior. This kind of policy of appeasement, which is what it is, has created a groundswell of assumption that polygamy should be legalized. It's in effect crypto legalization by the Attorney General's office that's supposed to be enforcing the law. Now, if there are enough elected representatives in the state of Utah that think polygamy should be legal, they should legalize it. I mean, obviously you have a problem with your state constitution. You'd also have to do a constitutional amendment. But setting that aside, if that's the policy that should be legal, then that should be the law that's enacted. But until it's enacted, it's criminal, And it is not something that an attorney general has the power or the right to ignore just because they decide to, for whatever reasons. Finally, the United States is well behind the curve internationally on many human rights issues, but on this issue, we are particularly behind the curve. In the United Nations, there is a group for the elimination of discrimination against women and children. It is aimed primarily at polygamy around the world. Why? Because of a finding that polygamy is inherently abusive and unequal. Unequal in the sense that women and children are in a worse position than are men in these societies, not just here, but elsewhere around the world. That seems to me to be an indication that there needs to be rethinking about why we would create the marriage laws that we have. I have nothing against a debate, a public debate, about polygamy and whether it should be the form of marriage or not. That's perfectly appropriate. And a religious exemption may well be appropriate. But until there is an exemption, until there's a democratic process, no religious entity or individual has any right under any constitutional provision to say that because their religion says so, they can ignore what is the rule of law in their own jurisdiction. Thanks very much.
Well, I feel like that the critical question this evening really is, what would Joe the plumber say about this? And I must say, I called Joe and he did not return my phone call, so I don't know. Let me say this. First, I've got to say whatever I say tonight is a matter of my own opinion, and that's critical for people to understand because I can't stand here and speak on behalf of the Attorney General's office. I don't think that would be appropriate. So for those of you with the media, I hope you will respect that. I hope you will understand that and know that if we're going to have a debate here, I have to have some liberty to talk about things that perhaps I don't even necessarily personally believe. But let me tell you where my fundamental problem is with this opening statement. The word assumption. And from what I've read, I have some real constitutional doubts, challenges about some of the stuff that's been written by Ms. Hamilton with regard to being able to assume things about people. I will tell you that I think that that is dangerous. I think that the Constitution does not allow a prosecutor to assume things. What the Constitution of the United States, as far as I'm concerned, dictates is that I can't assume anything. I have to provide evidence. Evidence that is substantial, believable to a court of law. And so when she says that we can assume things, that all people are abusing kids because of a lifestyle they may be living, I don't believe you can do that under the Constitution. I don't. I've never tried a case as a prosecutor in which I stood up and could say to the court, I assume this. I believe it. What I'm dictated to do as a prosecutor is to produce evidence that proves that. And here's my issue. You cannot paint with too broad of a brush these kind of issues, because when you do, you have major flaws. This is not just true for me in this context and talking about this issue. Frankly, it's true all over our society. Whether one is a Muslim and goes to a mosque, and what does that mean? Does that mean that all Muslims who attend a mosque believe that the United States should be attacked? There are issues with not dealing with facts and dealing with assumptions that get us into trouble. And all I know my whole career as a prosecutor is when I took an oath to uphold the Constitution. I believe that. I have to do that. So, should somebody be prosecuted for child abuse? Absolutely. And I will tell you that I take offense at anyone who says that the Attorney General's office in the state of Utah does not do that, does not have the desire to do that, because we do. Now, I will tell you that it's easy to sit from afar, and it's easy to write and say Utah doesn't have the desire to do their job. That's dangerous. Because I don't believe that Ms. Hamilton has sat in my shoes. I don't believe she has sat in my screening committee cases where we've looked at cases, where we go through meticulously and say, is there evidence that this individual committed this crime? Is this evidence admissible in court? Has it been constitutionally obtained? Because we do that all the time. And when in fact the answer to those questions is yes, we prosecute those cases. Now, this issue of prosecuting cases in these societies, I will tell you, are difficult. She makes a comment in her writings that this, we've done this for years. We've done it with the mob. Cops go out and they infiltrate the mob. Well, you know what? That's true. And we, in our office, talk about that example. The problem is, folks, is that it's much easier to infiltrate the mob and get somebody in the inside of that situation to provide evidence, real evidence that can be introduced in court. That's not true here. Every case that has had a viable witness step forward, in which that individual is willing to take an oath in court and testify and provide evidence that a crime has been committed, we have prosecuted. Now, I know that there's an awful lot written in the media about speculation and hearsay. Oh, yeah, we hear this. We understand this. I hear it all the time, everywhere I go. I hear that this is happening. Well, in my world, I can't do anything on that basis. What I have to do is look from a constitutional standpoint at each individual case. I then have to ask the question, do I have evidence that this individual has committed a crime? If that individual has committed a crime and I have evidence for it, then I can proceed. I cannot take people and throw them in one big basket. Say that people believe this because they believe it, therefore they have somehow committed a crime. To say that is really naive. I see some of my friends out here who I respect as good defense lawyers, and I can tell you what would happen if I stood in a court of law and made assumptions. I said, because these people have certain beliefs, they therefore have committed child abuse. I won't get very far. And I will tell you that I think is probably rightfully so under the Constitution. I have some concerns, frankly, in this country with what I've seen in other areas. I worry about this war on terror, and I worry about constitutional rights of people and throwing them all in a basket because we assume, because of what they look like, where they go to church, where they were born, where they come from, they must therefore be someone that we have to go after. I think that's dangerous. I think that it not only is it dangerous, I think it's unconstitutional to do so. And so what I will tell you is that I'll stand here and I will tell you like I tell everybody, and I take this very serious. If there is evidence of child abuse, and frankly, I don't care if this evidence of child abuse is in Hilldale or Colorado City, or if this evidence of child abuse is in Magna or Kearns. That's irrelevant to me. It's irrelevant to me, frankly, what this person's religion is, what they believe. If, in fact, they have committed a crime against a child for which I can produce evidence in court, then that's what my job is. And I take that very, very seriously, and so do the people in my office. To say that we sit here in Utah and Arizona, and one thing that Ms. Hamilton has written, Utah has focused on one man at a time. By that, I think what she means is that we haven't gone out and just thrown this net over a whole bunch of people because they happen to believe certain beliefs. Ladies and gentlemen, I don't know how to do my job as a prosecutor. I don't know how to do my job under the Constitution except for one man at a time, one piece of evidence at a time, and evidence that can take me into a court of law. I will tell you that when it comes to children, the standard in our statute is imminent harm. That is a standard that the legislature has put in place. If a child is in imminent harm and we have evidence of that imminent harm, we should act. If we don't act, I think we're not doing our job. But once again, what does that term imminent harm mean? It means that I've got to have real evidence. I've got to have evidence against an individual to be able to act. That question, I think, is pivotal here. I won't take fault with any of my colleagues in Texas because, frankly, I haven't sat there in their shoes. I think it's dangerous as a professional to sit and talk about what people are doing or not doing until you really know about their case. And so I'm not going to talk about that tonight. I refuse to. I think it would be inappropriate for me to sit and comment on anything that happened in Texas because I haven't studied it. But I will tell you that I think that that is the fundamental difference that we're probably going to have tonight, as I believe that we have to do this one man at a time.
Thank you both. My first question will be for Professor Hamilton, and then, of course, Chief Deputy Torgeson will respond. You appear to argue for a full court press to eliminate polygamy through criminal prosecutions and child protection actions. But didn't we try that already in a much more conservative era, and it didn't work? Ultimately, the prosecutions were seen as persecutions, and it could be argued simply made the community more cohesive and more inclined to live in isolation. And the isolation is what Mr. Torgeson suggests makes it impossible for those cases of actual abuse to come to the attention of child protection workers and police. What makes you think we could do any better today? And along with that question, in light of subsequent decisions by the Utah Supreme Court, is black still good law?
I only get 3 minutes for that?
How many more questions? They would sound similar.
I'm efficient, but I don't know if I'm that efficient. Yeah, black is still good law, but there have been exceptions made for in proceedings involving adoption and presumptions. But I mean, basically you're saying that there was a time when there was an attempt, one attempt, to stop polygamy on a mass basis, and because there was a lack of will to carry out what was needed for the children in that circumstance, we shouldn't do it now. The problem remains, and this is something that my colleague hasn't addressed, is polygamy is illegal. Child abuse is very illegal, but so is polygamy. And it's easy to figure out who's engaging in polygamy. You just have to figure out who goes into which house. That's not hard. It is hard to figure out child abuse. That's one of the huge problems for children in the United States. Adults hide it. Adults are good at hiding it, and children are good at being manipulated so the abuse is hidden. But polygamy is not hard to find. And so if you know that even a small percentage of individuals in these circumstances are prone to abuse children, why wouldn't you enforce the criminal law? I don't think attorneys general have the option to choose which parts of the code they'd like to enforce. They'll enforce the child abuse code, but they can't find child abuse, but they won't enforce the polygamy laws, which are clearly illegal. I give Texas a lot of credit. Some of the charges against the 10 men in Texas are child bigamy charges, not just abuse. And some of them are failure to report abuse. And so in my view, that is the better way.
Well, I think we'll point out yet the difference. Polygamy is easy to figure out. It's not easy to prosecute. Who goes into what house? If I stand up in a court of law and say, I saw this individual go into this house, I'm going to get laughed out of court. I think it's naive to say that this is easy to show or to prove. Now, I will say this. I haven't said anything about giving a pass to child bigamy. I will not say that. I believe that that is a crime that ought to be enforced, that ought to be enforced in every case in which you can prove it. And I have said that for 8 years without exception, and I'll continue to say it. But this idea, this sort of, it's easy to prove. People cohabit with each other in many instances, in many circumstances, all the time. Who goes into what house doesn't prove anything. And so, I think that the difference here is that you make it very easy you make it sound very easy to make such cases. In my experiences, that is not true. As to prosecuting all adult consensual polygamy, let me tell you, I've been in law enforcement most of my career. I have yet to see a day, and nor will I ever see a day, where we have the resources ever to go after this amount of crime, let alone every crime that occurs in our society. I'm inundated right now with mortgage fraud. Cannot even begin to tell you the number of mortgage fraud cases that cannot be worked up and prosecuted because the numbers are so significant. I'm inundated with identity theft cases, which I can't do all of them. And so it comes down for professionals in the law enforcement world to say, limited resources means I have got to make some choices. I've got to use the resources in the ways that are going to make the greatest impact to my community. And when that comes to violent crime, or it comes to this fraud that I think has engulfed the country and is horrible, those decisions are made. And we don't simply have the resources, nor do I anticipate the legislature giving us 100 agents to go out and make polygamy cases. So the real world, the practical world is we have to make tough decisions every day. We make those decisions to go after the cases that have the greatest impact to our communities.
Well, I think we've just had evidence of how far the Attorney General's office has come from the law with respect to bigamy. The definition of bigamy is not just marriage, it's cohabitation. Mere cohabitation is bigamy under 76-7-101. Unlike other states where common law marriage is proven after 10 years or 5 years, it happens almost immediately in the state of Utah. So I don't think that look, here's the problem. Here's the primary problem. The question is, how do you save children in circumstances where they can't save themselves? That's really the question. And my whole career at this point has moved to that fundamental problem in our society, which we have not solved at all. If there is one entree to get to more children that are likely being abused, then we need to be taking it. And if it's going to be through polygamy, which is already a crime, that doesn't seem to be a very difficult thing to do. Now, I understand resources, but I understand will as well. And it is in many states, children are not the highest priority. And it is my hope that we are having a civil rights movement for children starting, so that children will start to matter more than the adults who abuse them and hold them in abusive situations.
Question for Mr. Torgeson. Both of you seem to agree that isolation is a difficulty, and Professor Hamilton seems to believe that the question of polygamy, legal or not, is a legislative question. So, if we are not going to prosecute bigamy robustly, why don't we make that lifestyle legal? That way, there will be no reason for secrecy, and maximal opportunity for free choice amongst women who some allege are trapped in the community, and no reason for children to be hidden.
And you're asking me
Yes,
this?
yeah. Why not change the law?
Well, that's a prerogative that the legislature has. And I've told people that if they feel strongly that that's the way to go, they ought to go advocate for that. That is not a decision that somebody in the Attorney General's office makes. We don't get to make it. And Ms. Hamilton's right. We enforce the laws. That's what our job is. My point was, as I understand bigamy very well, my point is that there are crimes that occur in our community every day that I don't have the resources to go after. And so it's not that we're given a pass or we're just saying we're not interested. It is a matter of resources for us. But to your question, I would simply say that it's a debate that ought to happen at the state legislature.
Would you favor making the reason for secrecy and fear and isolation disappear?
Well, let me answer it this way, because I'm not going to answer that directly, and I don't mean to frustrate you, but...
But I do mean to frustrate you.
I know you do. You know, there are let's take adultery, let's take fornication. There have been laws on the books for as long as I've been a prosecutor that I can tell you the last time the state of Utah prosecuted somebody for adultery has been, well, I don't know. It's been that long ago. So the issue is when you start to talk about truly consensual adult activity, especially adult activity that occurs in the privacy of their home, and this is what Lawrence versus Texas talks about. There is an interesting debate that people can have about whether or not what Lawrence v. Texas says is if it's truly consenting adults and they're engaging in the most private act an individual can engage in, whether or not there isn't some protection from a privacy standpoint, or could be some protection from a privacy standpoint under the Constitution. So I could tell Ms. Hamilton, she could berate me for not having prosecuted adulterers and fornicators, and we have not done that because of the same reason. You know, limited resources, does it make sense? Is it the greatest bang for the buck? Is this what the community really needs? And the answer has simply been no. We have much more important things we need to go after.
Well, under Utah law, adultery is a Class B misdemeanor. It's not a felony. Bigamy and child bigamy especially are felonies. So I think the state legislature has already decided that there's a difference between adultery and bigamy, and if you're going to conclude that you have limited resources, it seems to me you'd go after polygamy long before you go after adultery. But having said that, Lawrence v. Texas is a case about the privacy of sexual activity between two consenting adults. It says nothing about the ability of a private individual to decide how the state will define marriage. Marriage is a legal construct created by a state which determines inheritance, legitimacy, obligations with respect to not neglecting children, obligations with respect to not abusing children. It is a legal construct. So Lawrence doesn't answer the question. It doesn't begin to answer the question, and we're not talking about sex tonight. Polygamy is polygamy whether the individuals are having sex or not. The question is whether or not they are deciding that the building block of the society is going to be determined by the laws of the society or by private, religious, or non-religious viewpoint. And it's my view that marriage is something that must be determined by the society and the legislature and not by individuals who the Supreme Court in the Reynolds decision have decided that they will be laws unto themselves.
Let me press you a bit more on Lawrence versus Texas then. And as you know, and many of our audience know, the Supreme Court held that laws criminalizing certain sexual conduct between consenting adults violated the Due Process Clause and wrongly denied them liberty. Why doesn't this liberty interest protect men and women who have sex in plural families? policy-wise, why do we criminalize sexual unions but protect sex without commitment? Why do we criminalize committed sex but protect sex without commitment?
Are you asking me?
Yes.
It's irrelevant. Sex is not what marriage is about. The definition of marriage is about the obligations with respect to inheritance and property ownership, and if children are produced, the obligations toward the children. But it's not about the act of sex. And so is the sexual activity protected? That's what the court said in Lawrence v. Texas. You may agree or disagree with that decision. But the court has not begun to say that there is any kind of individual right to unilaterally define what is going to be the basic building block of society. That individuals cannot do. And if they were to do it, they would deeply undermine the predictability that we have with respect to inheritance, legitimacy, and protection of children from abuse and neglect.
Can I respond?
Obviously, some of these questions give me some concern, and I will reiterate again, this is for purposes of, I guess, of debate. I have to tell you that. If you look at she says that adultery is against the law, but, you know, we ought not to be as concerned about adultery when she just told me that I'm ignoring going out and enforcing all of the laws. So, you know, you can't have it both ways. The argument could be made that when someone goes out and commits adultery, the fraud involved, the fact that that violates the family trust, that typically ends up in splitting up families, creating misery, the argument could be made that in some respects, is worse than an individual who says straight up, this is the way this relationship is going to be. And so you can get some inconsistencies with these type of situations. We give the pass to the adulterer, we give the pass to the individual who perhaps, not for religious reason, cohabitates with 4 women, all of which he may have intimate relationships with. Well, let me tell you, I mean, what's the difference? You could make the argument that somebody who was straight up to an individual and says, this is my lifestyle, this is the way I choose to live, I'm going to be straight up with you, do you want to engage in this with me, is much more honest and much more fair than is the adulterer or the fornicator who goes out and through fraud does that kind of activity.
Do you want to respond?
Well, you know, that's the best argument we've had tonight for legalizing polygamy, right? Right? That's the argument for legalizing polygamy. But that's not what the state's done, and I'll just reiterate that if you're going to have limited resources, it seems to me that you would enforce your felony law before you would enforce your misdemeanors, and child bigamy is a second-degree felony, bigamy is a felony, and adultery is a misdemeanor. So I'll grant you the limited resources, but I won't grant you the ability to determine for the legislature what are the more heinous crimes, which have already been determined by the statutes.
You know, we just prosecuted an individual in this state who stole $180 million from people. And let me tell you something, the devastation that brought on people, I will tell you now, that if you ask me, is my resource going to go to an individual that's done that kind of devastation to someone, or am I going to go after consenting adults who are engaging in an activity? I'll tell you right now, and I won't apologize, that I'm going to put my resources towards that crime, which I believe is much more heinous. And those decisions have to be made every day. If I could look in this audience and say, I am going to prosecute every one of your identity theft cases, if you've been burglarized, which is a violation, anybody who's had that happen knows it's a horrible event, I'm going to go after every one of your cases. Every white-collar crook who's in this state, I'm going to go after every one of those criminals. I'd love to say that. I can't say it, and I've never been able to say it because resources won't allow me. So it's naive to say that we don't have to make judgment calls that are tough, every day because we don't have the resources to do it all.
I'd like to ask the next question to Mr. Torgeson, and I want to turn from the criminal prosecution a bit to the child protection. Your position seems to be ignoring polygamous practices as such, but there is strong evidence that there are some isolated communities in which underage marriages or sexual unions are encouraged, and young men are excluded from those communities. Do you see these communities as presenting special challenges for child protection? And are we using the child protection laws to protect these children to the fullest extent?
That causes me tremendous concern. And I can't tell you the number of times I've had conversations about that. I have communicated for 8 years to people in the polygamy community. Many of them are here. They've heard me say the same thing. What happens to kids that's illegal within that community is something that the state ought to bring every resource it has to bring to try to get that case to court. And I believe that with my whole soul. Those kids are the ones I worry about. Now, under our statute, and I think most statutes, the law says you've got to prove to remove a kid from a home imminent harm. Imminent means that that harm is about to happen. And the only thing I've ever known is that I have a responsibility, or my child protection lawyers have a responsibility to go to court with evidence of that real imminent harm. Not one of my child protection attorneys can go into court and say, because these people believe in polygamous views, this child, therefore, is in imminent harm. There is a disconnect there that we can't do it. I have got to have something to produce to that court. Now, if in fact I have evidence that there is imminent harm, absolutely. Every one of my lawyers are dedicated. They would take that to court and they would remove that kid in a heartbeat. But again, the difference we're talking on two different planes here. One is sort of ethereal, and it'd be nice in a perfect world to be able to do this stuff. And the other is the reality of having to have real evidence, real facts that you can present to a judge to make a determination.
Professor Hamilton, response?
Well, I wish I lived in an ethereal world. That's where I lived when I thought that the Free Exercise Clause should protect people to the hilt. Unfortunately, I don't, and I am deeply educated about the amount of abuse in our society. This brings to mind one of the facts about Utah, very sadly, is that for child abuse litigators, especially those involved with clergy abuse, this is the worst state in the country. The Utah Supreme Court has issued a series of rulings that are absolutely unthinkable in other jurisdictions. So in some ways, maybe the Attorney General's office is just part of the larger culture, but it is much easier to ignore and get away with child abuse in the state of Utah. Last year, they came down with the Colosimo case. Colosimo case is outrageous. It says that two boys who were abused by a priest, and the abuse was covered up, and the reason they were abused is because no one told them that that priest was an abuser, even though the diocese knew. What the court said is those boys, now adults, could not bring a case 30 years later because when they were abused, they should have known that that diocese was covering up the identity of their abuser. Right? Wisconsin's a very tough state to win in these cases. Wisconsin did not come down with that rule. Colosimo is an embarrassment, and it's just a problem that is for children. When you have an Attorney General's office that is willing to say they just can't find the evidence, what that means is they're not trying hard enough. And I know they don't like to hear that. Well, but someone has to say that because it's a fact.
You know, that is, you know what, I guess I'm astounded at the naivete in that statement. I'm not kidding you, Miss Hamilton, because I live this. I don't write about it from some office back east. I live it. And I have got to sit in cases where I have got to ask, where is the evidence that this is going to be proven in court? Now, you can say that this is easy, but
I didn't say it was easy. I said
No.
you weren't trying
Well,
hard
let me
enough.
ask.
Very different.
Well, then I'll tell you what, I'll make you this offer. I'll deputize you, you come out, you make these cases, and let's talk in a year from now.
You know,
Because it is not easy. And let me tell you, it isn't for a lack of caring or a lack of trying, and that's where I take the greatest umbrage. I will tell you that. Because we have, and you made fun of the safety net thing. I know you think that, well, that safety net program was put in place for one reason, to establish a relationship with people in those insular communities to feel like they could come and talk to the government, have a communication with the government, and if in fact there is evidence that a crime is going on, they would be willing to come in and tell us about it. That's what that program is about. But until somebody walks into your office or you're able to find evidence, it is not for a lack of trying. And I think that it is somewhat disrespectful to not live it and to make some assumption, again, that you really don't know whether or not it's true.
Well, I guess the hundreds of clergy abuse victims that I have personally represented don't count. Look, there's a lot of abuse out there. And the question is, do we have the will to stop it or not? Some states have a greater will to stop it than others, and some states have a greater will to stop it with respect to some perpetrators and not others. I'm not going to question anybody's motives, but I am going to question results. And the results in the state of Utah is that polygamy has proliferated, that it is the largest percentage in the country, and that we know that abuse occurs and is not being caught. And to the extent that abuse occurs and is not being caught, this state is going to pay from ruined lives. I have to laugh, $180 million. How much does one child's life count? If a child is sexually abused, their life, in many circumstances, is ruined. And anybody who would suggest otherwise hasn't spent nearly as much time with abuse victims as they should.
Well, you have prosecuted, and I applaud that, or you've litigated cases of abuse victims in clergy cases. Ma'am, the difference is you had a victim come to you and say, this abuse occurred to me. I challenge you to point to any case in Utah in which a victim has presented themselves with real evidence that the Attorney General has not acted on it, because you can't do that. You can, again, make broad statements that, in fact, we're just not trying hard enough. But you know what? When people are not willing to come forward and say, this is what happened to me, anyone who has done child abuse prosecutions for any period of time knows that until you get to that point where the victim's willing to come in and take an oath in court and say, this is what's happened to me, you don't have the evidence. The one thing you keep glossing over in every one of my responses is this need for individual evidence in individual cases. I keep hearing that somehow it's just for a lack of resolve.
Children don't come forward about abuse on their own. It's just statistically true. They normally take into their 30s, their 40s, their 50s. I heard from a man who was 75 last week who had never told a soul about his abuse in a religious home. So you can't wait for the children to walk out of the house and say they're being abused and they need to be protected. You just can't do that.
So you're
and
going
one
to
of
their
the
home?
keys is to stop the other illegal behavior. For example, illegal drug use is a good way to stop child abuse. Now, I understand polygamy is not illegal drug use, it's just they're both felonies. And the reason for stopping one is the same as the other, because the legislature has said that they both need to be stopped.
Professor Hamilton, it seems that you're really highlighting the dangers of authoritarian religious communities to children, and particularly children when they are in isolation. Yet you advocate extreme intervention, prison and foster care. Why isn't the more effective intervention the one we already guarantee every child in the Utah Constitution? A public education system open to all children. Why isn't that the first step in enforcing children's rights and a right not to be isolated?
Well, I happen to think that's part of the package, is making sure that children are fully educated across the board. I'm on record as saying that I think the worst decision the Supreme Court's ever decided under the Free Exercise Clause was Wisconsin v. Yoder, where the Supreme Court said that the Amish did not have to send their children all the way through school under compulsory education laws. For children, that was a disaster. I live near a number of Amish communities in Pennsylvania, and the children who don't stay in the community come out with an 8th grade education. You can't get any job with that. So, yes, I think that education is key. I also think that public education about children's rights not to be abused and not to be in situations where illegal activity is occurring is also important. Hard to do with isolated communities, that's for sure.
Mr. Torgeson, do you want to address that question? Why not public education as a less intrusive intervention, but an opportunity for the children to have access to other adults in their lives?
Well, I think that is an important thing, and I can tell you that Arizona has done a tremendous amount on that issue. It's something that they looked into it seriously, and I applauded that. I believe that education and having education for these children is critical.
We've got consensus, okay.
We'll agree on
In
education.
which case, I need to ask an insulting and tough question for Mr. Torgeson. When the FLDS case was brought in Texas, there was a flurry to distinguish those people from the LDS Church that does not practice currently plural marriage. Are we doing less than we could or than we should to avoid negative publicity that these cases would evoke about Utah? You're going to say no, but you know. Are we motivated at all? Not you personally, but might there be some motivation to not do things that will bring public approbation on our state by making cases that make the front page of national newspapers?
Well, I don't believe that. No, I believe, as a prosecutor, you make a case, you take a case in which it's presented to you with evidence, and when that evidence is sufficient, then you take it to court. And I feel strongly about that. I guess my point is I believe that I still have not heard of, where this difference is. There's a point to the fact that Utah doesn't have, I guess, the guts to step up and do this. We do. I mean, I will tell you that the Warren Jeffs case was a tough case. It was a hard case. It was a novel legal theory, frankly, that wasn't particularly, we did it. I mean, there hasn't been cases that, have come forward where we had a particularly, I think, heroic young lady who finally said, I'm willing to take the stand and testify. In Rodney Holm, we had another heroic young lady after a lot of going back and forth who finally said, I'll take the stand and testify. But until, the 30 or 40-year-old abuse victim is willing to say what happened to them, I still fail to see how one comes up with evidence that's sufficient constitutionally to charge that person with anything. And that's just a major, I guess, point of difference.
Well,
for us.
I think one of the major problems in Utah as in other states, and that actually hamstrings your efforts, is the statute of limitations is much too short, so that the victim who's not ready to come forward till they're 30, 40, 50 has been shut out of court for a very, very long time. And were the state to do what I recommend in the book I've just published, Justice Denied, and get rid of the statutes of limitations for child sex abuse, those claims could be brought when they're ready to be brought. And that would make it easier for you. That would make it easier for the victims who are right now sitting outside the courthouse because of that. So, it's a problem across the country. Delaware has done the right thing. They've abolished the statutes of limitations, both civil and criminal. Other states have it on the books, and others are considering it right now. And the problem is we're just now figuring out that our child sex abuse victims can't come forward when they're still in the home. That's for sure, the incest victims. And the abuse victims who depend on that home. And so I think really part of the answer here is loosening the statute of limitations so the claims can be brought.
Do you want to respond?
I'm fine with that. I'm absolutely fine with that.
Professor Hamilton, one of the issues, let me set aside, no. You object to teenage girls being coerced into early marriage and childbearing. But American society at large has a high rate of teen sexual activity and a high rate of births to underage mothers. Why are polygamous teens supported in having early families worse off than the 16-year-old pregnant girl whose parents convince her to marry the father and keep the baby?
I don't think either one of them is looking at a really great horizon, are they?
But you're not asking us to prosecute the parents of that 16-year-old girl for child neglect by advising her to do something that may be very unwise.
I certainly would if the parent handed the child over to an adult. That's illegal. Of course I would. Children are having sex and having babies at an unconscionable rate, and worldwide, compared to the rest of the world, we don't look too intelligent. And I think that's a huge problem. But I don't see that failing to enforce polygamy's got anything to do with that particular aspect. The presumption that a girl who is brought into a polygamous situation when she's a child and starting to have children one after the other is not in a dire situation, is just a notion of women that is unacceptable in our society. All of her opportunities have been stopped. Her opportunities for education, her opportunities for her own situation. I didn't have children until I was 30, thank God, because they're tough. It's hard to have children. And the notion that you would saddle a teenager with a child and then say, gee, they must have had a really nice life, is just not real.
The tragedy of these cases, and I will agree with Ms. Hamilton in this regard, young women need to be allowed to reach the age of maturity and to make proper decisions. And I have never wavered from that, and I think everyone in this room who's ever heard me comment will say that that's what I've said. I've said it to people in this room to their face, and I will tell everyone. The tragedy of these societies is that if there's any influence put upon a young girl to marry somebody she doesn't want to marry at an age that she shouldn't be marrying somebody, that's outrageous. And I will tell you that there is no religious get-out-of-jail-free card for that activity. So the message has been from day one, we allow people to reach the age of adulthood and make decisions, not always good ones as we know, but make decisions once they reach that age. So to the polygamous communities, I have said that and I'll continue to say it. The tragedy, if it exists, is if anyone tells me, and I believe this has happened, we're not going to do it anymore, and I believe it has happened since then. And that bothers me. That bothers me tremendously. And I have communicated that to the very people who know how much that bothers me. Because here's the issue. If we're really going to allow adults to make bad decisions in our society, then let them do it. But these young girls in these communities who, if they're forced or brainwashed or whatever, to get into these situations at a young age, it's appalling. And I think that, I will tell you once again, if I have evidence of it, I'll tell you that I'm passionate about that, and I would take any one of those cases to court if I had the evidence.
Last question before we turn to questions from the audience. So I'm hoping my question collector is Professor Threedy here, sorting through questions, being ready to give me audience questions. Last question for Professor Hamilton. Criminal prosecution would result in, at most, the imprisonment of a perpetrator for a short period of time. We're not talking life sentences, we're talking a few years.
Right.
A child protection case involves not only statutory claims of abuse, neglect, and could be psychological neglect or abuse, and risk factors, but also constitutional rights of the parents and child to have a relationship. And once you're having a child protection case, we've already got a child with a relationship to parents. And a statutory scheme that requires services to try to reunite the family. Mm-hmm. How do you see a massive litigation of protective cases playing out based purely on the fact that the children are being raised in a polygamous community?
Well, I think there's combined wisdom in both how some of the cases played out in Texas and the 1955 Black case here, which is that in the Black case, to the extent that the parents were willing to say that they weren't going to continue to engage in illegal behavior, they could retain custody of their child. The reason they did not retain custody was because they refused to say that they would not continue illegal behavior. In Texas, there are a variety of parents who did not return with their children to the ranch, partly for the purpose of proving that to CPS that they were going to take care of the children. Now, maybe that was just a ruse early on, and they have all now returned. But to the extent that the children are protected from the illegal behavior, I don't have any need for prison. But to the extent that a parent is insistent that they're going to engage in felonious conduct, I agree with your Utah Supreme Court, which said that that's evidence of unfitness as a parent.
I struggle with sort of this concept of going in a kind of a whole scale, go in and take every kid out of a situation because there just may be something going on. I got to tell you, there is the other side of this that frankly, my child protection lawyers are some of the best in the country. I think if they were here, they would tell you that the removal of a child from a familial situation can be traumatic, can be damaging, and it can be very harmful. And I think that any good social worker or child protective worker will tell you that that needs to be factored in here. If a child is not at imminent risk of harm, let's say they're not at risk of any harm to themselves, physically or emotionally, going in and taking that child and removing them from the family and the people they love can be a horrific event. I just hope we understand that. I got to tell you, my feelings, my heart goes out to some of these children who are all of a sudden plucked from an environment which they're not being exposed to any true imminent harm at all to themselves, and they're hauled off hundreds of miles away by the government. There is a price to pay there. And so I think that people who make these policies say that, you know what, there's a balancing of interest here. We don't want it to go, the pendulum to go way too far to either extreme. And it's this mass going in and painting with that broad brush that everybody must be within the same group or the same condition that concerns me. And as a lawyer, I don't believe that in our state that would fly. And I'll tell you why, because I know that my lawyers have got very tough time deadlines. They got to get in front of a judge. They've got to produce evidence and facts which can be substantiated for that removal. One of them go in and there isn't those facts or that evidence of imminent harm, the kid is ordered by the court to go back to the family. And so it is that, again, I guess that difference that we continue to come upon that I think you've got to have it be an individual case with facts and evidence to prove something's going on.
Well, I agree with your hypothetical, but that's obviously not Texas. You had a small, isolated community with 10 indictable men engaging in sex abuse. That's a problem. And they're indicted under the grand jury system, not under some kind of preponderance of the evidence system. So if you had a circumstance where you could say that the children were not in an environment where they were going to be abused, that would be one thing. But when you have a very tight-knit community and there are 10 men that are capable of being indicted on abuse, first-degree felony in Texas is child bigamy, and failure to report abuse, in other words, they didn't care about the abuse, seems to me that it's easy to put those men in jail.
But I agree with that. But what if there is a man and a woman who lives in that situation, who's decided that monogamy is really the lifestyle they want to live, they may like the community, and you're advocating going in and saying, I'm taking this child from this home because you live in a community that a couple of people may be breaking the law. And I've never understood the law to allow you to do that.
Well, if it were a drug den, it would just be a simple conspiracy claim, wouldn't it?
Well,
Yes, it would.
No, let me tell you this.
Conspiracy.
If it were a drug den and you had drugs in the house, I'd go in and would take those kids out and I'd have wonderful evidence to present to a judge that says these kids were in a house with drugs.
I know.
But what about if there was an apartment complex and they all got along real well and the apartment 4 apartments away were sitting there watching TV with their kids, never engaged in drug abuse? Do the officials knock on the door and say, we're taking that kid out of this apartment because you live in an apartment complex in which drug abusers have exposed their kids to drug abuse? I don't think so.
Well, if you have 10 girls that have been clearly pregnant before they were supposed to be, in other words, statutory rape victims, in a small community, and you had men who were having sex with them, and everybody attended the weddings and everybody celebrated the handing off of the girl to the adult, doesn't sound to me like a situation where you don't have conspiracy. All the adults are co-conspirators in the abuse of the children. It's really no different than a prostitution ring, except for the beliefs. It's no different.
Let me turn to some questions from the audience, and I have 2 questions that sort of go together to Professor Hamilton. And here in both of these questions, we're going to ask you no longer to worry about the 13-year-old being married off to an older man. Ms. Hamilton, as a fundamentalist Mormon polygamous dad who is absolutely against abuse and who will not give up polygamy, what would you suggest as far as creating an environment where abuse can be reported without being fearful of being prosecuted for bigamy? There are many like me who want abuse to stop, but not plural marriages among consenting adults. There are already many eyes in plural communities who will report abuse should their consenting adult relationships not be put in jeopardy. And similarly, a second card. In a nation where gay marriage is becoming legal, where killing an unborn child is legal, why can I not live my beliefs as long as I, 1, do not commit incest, 2, do not marry a child, 3, pay my taxes, i.e. not live off the system, 4, do not marry someone against their will, 5, and I love, respect, honor, and take care of all of my family, 6, and allow them to make their own choice to live the same lifestyle or not?
Well, I urge both of you to make your case to your state legislature. I can't make it legal. The state legislature has to make it legal. No matter how good of a life you're living, if you're engaging in criminal activity, until you persuade the state legislature it's not criminal, it's still criminal. The fundamental problem here is the axis between democracy and religious liberty. Does religious liberty overcome the democratic legislative process? And the answer is no. Not the United States Supreme Court and not in any kind of civilized community. If those are the arguments, obviously you're going to keep child abuse illegal. Get polygamy declared legal in your state. That's the answer. It's not give you a pass.
Do you want to respond? You don't have to. I have questions for you.
I'll take
Here's a
another question.
This is a different topic. The Utah AG does not prosecute polygamy per se, but the Utah AG participates in keeping polygamists from being law enforcement officers, attorneys, holding political office, and voting in some instances. Why is it advantageous to persecute instead of prosecute? I
Well,
guess the persecute is referring to.
The statement that we don't prosecute polygamy really isn't accurate. I mean, we have prosecuted those cases. I will tell you that they are those cases in which typically it involves somebody who's underage, those kind of cases, because we feel like that's where the resources should go. It's an entirely different issue for me, for anyone who's going to put their hand on the Bible and swear to uphold the Constitution. And if a police officer or a judge or anybody in a position that has to swear an oath to the Constitution says, I'm willing to do that and obey all the laws of the state, then I think they have to make a fundamental choice that does include all laws, whether you like them or not. And so I don't have a problem with that. And we have actively been involved in decertifying police officers in those communities. And I will tell you that I am okay with that, because my fundamental belief that what happened was that their religious beliefs and their adherence to their prophet took precedent over enforcing the law. That is not okay. And so for those police officers who didn't want to uphold the law, and I believe that's true, they shouldn't be a police officer.
Okay. Professor Hamilton, and perhaps you want to follow up with your last answer, because you addressed the question about changing the law, but not the question about whether you would still argue that children should be removed from those families. And this is a follow-up question. If we should remove children from their family because of, quote, likely abuse, how does this help children? Doesn't removing children from people they love and inserting them in a broken foster care system constitute an abuse?
I am not going to defend the foster care system, that's for sure. It's another aspect of what I've come to call adult preferentialism. We really do prefer adults over children. We don't give children the protection they need. And so is it from the, one difficult situation into another? It may well be. I certainly can't dispute that. But both need to be fixed for the sake of the children and not just perpetuating the other.
Here's a question for Mr. Torgeson. Why don't you prosecute fathers in polygamous relationships who you can prove have underage wives bearing children? Won't DNA make your case? And here, I guess, the inquiry goes to why aren't we checking birth records and so on?
Well, we would if they existed. These situations, the reality of it is if it is a plural wife, it is a second wife or a third wife, they don't go down, at least in my experience, and file the birth certificate with the state. That doesn't happen. And so, once again, the real world is it's not as easy as going down and thumbing through records and seeing birth certificates and saying, aha, there you go. The real evidence comes for us if somebody is underage. Typically, the evidence comes when there is a pregnancy. Because frankly, without the pregnancy, we can't prove what we have to prove. Now, you will all perhaps find this amusing. I don't. There have been cases in which the argument has been made by defendants and their defense counsel that you can't even prove that an act of sexual intercourse occurred. This could have been insemination through some means which did not, in fact, come about from sexual intercourse. So, one of the things we're looking at this year is changing the incest statute, for example, to say we don't care whether or not that happened. Because that doesn't matter to me. I mean, number one, I think that's bogus. You know, the baster defense is just that. It's just baloney. Well, that's exactly what it is. And so if, in fact, somebody wants to make that argument, what we're trying to do legislatively is just take that argument off the table. Don't be silly. Don't make it. If, in fact, that happens and we have the proof, we're coming after you.
What about polygamous groups that do not participate in child marriages or child sexual unions? And let me add, we've talked about polygamy as if it only exists in the fundamental Latter-day Saints religions, and here in Utah, we in fact have some refugees from Africa who were polygamous before immigrating here, didn't particularly pick to be in Utah, but are told when arriving, you know, you sleep with first wife, second wife, and her kids, you can support them, but you're not allowed to sleep with her anymore. Is your standard also to be applied to practitioners of the Islamic religion who practice polygamy, or animists, a-religious African polygamists?
Oh, of course, and I mean, absolutely. The polygamy prosecution I mentioned earlier in New Hope, Pennsylvania, was of a man who just happened to have two wives. There was no set of religious beliefs or ethnic anything. He just had two wives. Once again, it comes down to whether or not individuals can decide what the shape of marriage will be, or whether the legislature will decide what the shape of marriage will be. And I'm going to continue to come down on the side of saying that's something for our public deliberation and our publicly elected representatives, and not for any one individual. So whether or not they immigrated or whether or not they are here, whether they're religious or not, the law says polygamy is illegal.
I think it's now time that we should turn to your closing statements, and we've set aside 5 minutes for each of you to give a closing statement. Professor Hamilton?
My main concern is children, and it will continue to be children. And to the extent that we have means of finding abuse where we don't have means right now, we need to follow those routes. If, in fact, polygamy is an acceptable way to structure the society, both in terms of inheritance and in terms of legitimacy, and in terms of women's rights, and in terms of the protection of children. If all of those issues can be answered in the affirmative, then polygamy should be made legal in the state. But if they can't be answered in the affirmative, then there is no justification for either pretending it doesn't exist or pretending it's always benign, because it isn't always benign, even if it is sometime. I can't tell you how many times friends of mine from Utah have told me, but there's this really nice couple at the end of the street that happens to have some extra spouses, and they're good people. I don't have any doubt that there are plenty of good people who are in all sorts of relationships and circumstances, but that doesn't make them legal good people. And so the question is whether or not the state is going to take upon itself every weapon it can in the protection of children, or whether or not the state is going to decide that it will wait for children to come forward. In the end, I think one of the most important solutions is the statute of limitations for child sex abuse. Were it to be eliminated, much of the abuse in any group, whether it is at the hands of the Catholic Church, the Jehovah's Witnesses, or polygamous communities, or other private groups, no matter where it is, those victims could come forward and tell us who the abusers are. The way the system is structured right now, as you've heard, it's much too difficult for the rest of us to find out where the children are suffering and where the abuse occurs. And to the extent the law is keeping hidden the predators, the law is wrong. Thank you.
Well, this has been as rigorous as I remember this place being. I'm not so sure I
You
enjoyed it
invite you back
then.
every 22 years to torture you.
Well, let me say this. My point, and I've made it, I know, a dozen times, the difference here is the fundamental belief of what the Constitution requires. And the danger in disregarding constitutional principles. For me, that is the pivotal question here. The discussion that we had about the drug den, I think, was very enlightening. The drug apartment, and the fact that if, in fact, there's drugs being used and kids are present, of course, we're going to go in and we're going to remove those kids. But the issue then becomes, do you remove the kids from the downstairs apartment for which you have no evidence, no indication that anything has happened? I think that you cannot use that broad of brush purposely. See, I believe the Constitution requires that particularity. It requires evidence. It requires proof beyond a reasonable doubt for a reason. You know, when I did some defense work, Jim, I did a couple years of that. I loved a quote from John Adams, but you know, it was better that many guilty men go free than one innocent man should suffer. The obvious point is, a system is not a system that railroads people. A system is no good if, in fact, we don't have standards in which, if we're going to take away someone's liberty, we're going to remove their kids, we have to do it constitutionally. We have to have real facts and real evidence. I don't know anything different. I believe that that's what the Constitution dictates, and I'm frankly proud to uphold that. Thank you.